I'm Michael Gurfinkel, and welcome to another episode of U.S. Immigration TV. A question I'm asked a lot is, can I work while waiting for my green card in the U.S.? Well, the answer is it depends. First of all, a person can only work if they're authorized to do so by the USCIS. And a lot of times, many petitions take years and years before a visa becomes available. Let's say, for example, a brother to sister or sibling petition might take up to 30 years. Just because the petition's filed does not authorize them to already begin working in the U.S. for the next 30 years. They have to first file for work authorization. Now, when can a person file for work authorization? The only time they can file for work authorization is when a visa is available to them, which means their priority date is current. Now, if you're being petitioned as an immediate relative, such as a spouse, minor child, or parent of a U.S. citizen, then the priority date is immediately available, and it is possible that you could apply for work authorization unless there is some other issue in your case. Other family petitions and employment-based petitions, you have to go to the monthly visa bulletin published by the U.S. State Department and see where they are processing their priority dates in relation to your priority date. Now, a priority date is usually the date a petition is filed for family-based cases, and for employment, it is when the labor certification application is submitted to the Department of Labor. So if a person is petitioned, let's say as a married child or a brother or sister of U.S. citizen, and the waiting time is 25 to 30 years, they will have to wait all that time until the priority date becomes current before they can finally file for what's called adjustment of status and the work authorization. In addition, if a person is out of status in the U.S., they may not be eligible to apply for a green card or work authorization in the U.S. Now, I know it's frustrating, and people do want to work, they do want to contribute, but there are laws and rules to be followed. And of course, if a person works without authorization, it could affect their eligibility to apply for a green card in the U.S. Certainly, it would violate their status if they are not authorized to work, such as coming into the U.S. on a visitor visa and working. Immigration may be able to track that down. They may ask you for tax returns. They have access to the state employment agencies and can see if an employer is paying payroll taxes. If you have questions about your eligibility for a green card or whether you are now eligible to apply for work authorization, you may want to consult with an immigration attorney who can evaluate your situation, determine your eligibility. Maybe there could be other or faster ways for you to get legal and or be able to work legally in the U.S. I'm Michael Gurfinkel, and don't forget to like, subscribe, and share this channel. Thanks for watching U.S. Immigration TV.